Officer Dave, would you open the courtroom for us? Officer Dave, courtroom, please.
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Morning, counsel.
Good morning.
You got Ford Credit versus Johnson.
That's correct. Yes.
All right. We are on the record. This is file number 06-117606. Ford Motor Company Credit versus Felicia Johnson. Date and time for objection and garnishment. Your appearance.
Good morning, Robin Stradowski on behalf of Ford Motor Credit Company, P number 71195.
And what is your name, ma'am? Ma'am, what is your name?
My name is Felicia Johnson.
You're the moving party, ma'am. What is the
Yes.
basis of your objection to garnishment?
I'm sorry, sir.
What is the basis, ma'am, of your objection to garnishment?
Sir, because I was on disability and I just started like working like a year ago, a steady job. And I never received these letters at my address or anything. And all of a sudden I got this at my job. And they was taking money out of my check, out of my W-2 forms. So I didn't know how much they had took out or if I had paid it all up from 2006 to now. They was taking my income tax check. So when I got this, I think 14 days ago, I seen where I didn't understand that I owe this amount of money, that it was due to the fact of interest or whatever, sir. And I'm paying my bills, you know, that I'm paying now, like a place to stay, and they're taking almost $400 of my check. And I just wanted to know, I'm not saying that I don't owe the money, because when I got the papers and I looked back down at it, and I had somebody else had to help me look over it because I really didn't understand it. They did show me where it was the interest of, I guess, 17 years ago. And I just wanted to still be able to live. I'm not saying that I don't owe it, but I just wanted to be able to make some kind of payments because I can't afford it. That's all, sir.
Mr. Zowski.
And Your Honor, we did send her a payment history, so I think that's what she's referring to, that she now understands the debt. There is still a balance owing on this. We have received some money through tax garnishments in the past, but there hasn't been any voluntary payments since the judgment was entered on this case back in 2006. It was also renewed in 2016. I'd be happy to talk to her about a payment arrangement if the court would allow a stipulated order for installment payments, if that'll help her out.
Okay. Well, what I'm going to do is I'm going to make a decision on what's before me. And what is before me is the objection to garnishment. Financial hardship, ma'am, is something we all understand as human beings, but it's not a valid basis for objection to garnishment. The judgment in this case was entered on June 27, 2006, and renewed again March 22nd of 2016. You have failed to state a valid objection to garnishment. Your objection to garnishment will therefore be denied. You have an absolute right to appeal my decision. That appeal will be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out an order to both of you. What I'll do now is I'll put you two into a chat room. If you're able to work out a stipulated order, get the order sent into the court. Thank you both for coming in. Let's see if I can get you in the chat room.
Thank you.
Good morning. Waiting for Mr. Cheese to connect the audio. All right. We are on the record calling file number 19142-024. Razor Capital versus Cody Cheese. Date and time for objection to garnishment. Your appearances.
Yes, Coach Cheese is here.
Good morning, 8P77.
Mr. Nate, you faded in and I'll try it again. Oh, again. Days.
I can barely hear anything, Your Honor.
Well, we're getting ready to get started. He was having problems. So I put him in the waiting room and I'll bring him back. Hopefully we'll be able to get it better.
Okay.
Let's try it again, Mr. Nate. Can you hear us now?
Your audio is and as well.
Yeah, you're breaking.
Can you hear me?
Breaking up. All right, let's call your case and get started. This is file 19142-024, Razor Capital LLC versus Cody Cheese. Date and time for objection to garnishment. Your appearances. What is your name, sir?
My name is Cody Cheese.
Counsel?
Preston Nate 7784. Their capital.
Mr. Cheese, you are the moving party. What is the basis of your objection to garnishment?
Can you please repeat that, Your Honor?
What is the basis, sir, of your objection to garnishment? We're here because you filed an objection to garnishment. What is the basis of your objection, sir?
Okay, that was the DTE for this this collection was due to my ex-girlfriend, and she had used my name without me knowing, without my recollection of using my name. Then I received this garnishment from Steiner Raising Capital. So I want to see, can I get it garnished, not garnished, but taken away, because that wasn't me. I'm not the one that did that.
Mr. Nate.
See if I can log on a little bit better. It's a lot for me.
Go ahead, Mr. Nate.
Your Honor, the tax guard. Seems like at this trying to attack the management with tax garnishment. Tax garnishment was entered in 2009. I don't see really any evidence to the contrary point, but I think the court defendant's objection to tax garnishment is the objections that would to do.
Mr. Pate, you're virtually impossible to hear. Try it again.
Yeah, Your Honor, see if that were. I apologize for the sound.
Let's hear your response. Mr. Nate, do you have a response?
We would ask to take tax garnishment if he's attacking underlying judge to be a different motion held, as well. Judgment was in 2009 with defendant. I understand county may have a girlfriend, but it would ask the court a defendant's objection.
All right. Anything else you want to say, Mr. Cheese?
Yes. I also have text message that she's stating that she had full responsibility. I had called the court and the lady at the counter said it wouldn't stand in court and I cannot use that.
Well,
So,
here's the situation. Michigan Court Rule 3.101K specifically provides that you may not use the objection to garnishment to challenge the validity of the underlying judgment. And that's what you're attempting to do.
Okay.
You have therefore failed to state a valid objection to garnishment. Your objection to garnishment must be denied. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days today in the Wayne County Circuit Court. We'll send you gentlemen an order. Thank you both for coming in. We're off the record.
All right.
Get your sound fixed, Mr. Nate.
Oh, yep. I apologize for that, Your Honor. That's
ridiculous. All right, what have we got? Mr. Nate,
Is that any better?
that's much better.
Yeah, I apologize for that. I don't know what my phone was doing. I was trying to get on here. Just to confirm.
What file do you have, Mr. Nate?
That was the one we were just on with Cody Cheese.
Yeah. It's the motion, the objection is denied, we'll send out an order.
Okay, I figured as much, but I just wanted to confirm. Thank you, Your Honor. I appreciate it.
All right, have a good day.
You too.
Nine. Weberman, I know. Let's see who Mr. Best has. Mr. Best, good morning.
Good morning, Your Honor.
What brings you here today?
I'm on Chrysler Financial versus Player.
Player, I have Player. Let's get Player in here and let's get started. $389. We're waiting for Claire to connect to audio.
Okay.
We're having a lot of trouble today. I don't know what's going on.
Yeah.
It's not our system. It's always external. It's getting frustrating. Hello? Hello?
Hey, how you doing?
All right, we are on the record. This is 10104-389. Chrysler Financial Services versus Anthony Player. Date and time for objection and garnishment. Your appearances.
Thank you. Good morning, Your Honor. Daniel Best, P58501, on behalf of Chrysler Financial Services.
And what is your name, sir?
Anthony Player.
You are the moving party. What is the basis of your objection to garnishment?
I don't know what this is.
Do you have any other basis other than you don't know what it is?
No, sir.
Counsel, your response.
Thank you, Your Honor. You cannot use an objection to garnishment to attack the underlying judgment, which is what we view this as being. In response, though, I did check the application that Chrysler Financial received, and the Social Security numbers do match. I also compared the signature of the defendant on his motion with the signature on both the application and the loan contract. And they are, even though they're 15 years or 16 years apart, they are consistent. We view that we do have the correct individual, Your Honor.
Mr. Player, you were served with summons and complaint in this matter back in 2010, or May of 2010 to be specific. You failed to respond, and on July 22nd, 2010, a judgment was entered against you by default.
I never received anything.
And so the judgment was renewed, it appears, Mr. Player, on January 14th of 2021. In any event, Mr. Player, you may not use the objection to garnishment to attack the underlying judgment, which is what you're trying to do here.
I'm not trying to do anything. I was just trying to get to the bottom of this. Listen,
Bottom of this, Mr. Player, is that you were served with summons and complaint. A default judgment, well, don't interrupt me.
Sorry.
A default judgment was entered against you, and that judgment has been renewed. That judgment is presumptively conclusive until set aside, and that matter is not before me today. So the court is going to have to deny your objection to garnishment. You, sir, have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out to both of you gentlemen an order denying the objection to garnishment. Thank you both for coming in. We are off the record.
Thank you. Have a good day.
Too, sir. All right. All right, let's see who.
the suit of what they did.
Good morning, Judge.
You know, I didn't know.
I'll come back to you.
Thank you.
Mhm. Mr. Weberman, good morning.
Good morning.
What do you have?
There's a show cause that was adjourned to today.
With Mr. Hill?
Yes.
Okay, hang on. I think I have him here.
Right.
Hello?
Hello?
What is your name?
David Thornton?
David Thornton.
Yes.
Okay, you're not the person I thought you were. Let me see. Mr. Weberman, I don't have Mr. Hill as of yet. Mr. Thornton, I don't have your opponent as of yet. So I'll put both of you gentlemen back in my waiting room.
All right. Thank you very much.
Sorry, Judge, I'm still in this hearing. I apologize. It's been going on since 10.
And throughout the whole thing, what
I'm gonna go on. Good morning.
Good morning, Your Honor.
What brings you here today at 10:26?
This is David Karen. I was here for the matter of City Financial Corp versus Gail Finney.
That's a 10 o'clock call, counsel.
I apologize, Your Honor. I was in Judge Coleman's room on another matter.
All right. We are on the record calling file number 01-102-743, City Financial Corp versus Gail Finney. Date and time for objection and garnishment. Well, not the time, but the date. Appearances.
Yes, Your Honor. Good morning. David Karen on behalf of plaintiff P42236.
She just walked away. Hello?
Oh, yes. Okay, there we are. Good morning.
This is 01-102-743, City Financial Corporation versus Gail Finney. Ma'am, what is your name?
Gail McKennedy.
I'm sorry.
Gail McKennedy.
Who is Gail Finney?
That was my married name.
You are the moving party, ma'am. What is the basis of your objection to garnishment?
My objections is that it's been over almost 29 years now. I'm not familiar with the people that's garnishing me at this point. And that's my concern with it. And it's been, like I said, over 29 years, and I'm not even familiar with the people that's garnishing me.
Do you have any other basis for your objection to garnishment?
I'm sorry, sir. Say it one more time.
Do you have any other basis for your objection to garnishment other than what you stated?
No, sir. It's just been too long and I don't know who they are.
Counsel, your response.
Yes, Your Honor. The defendant's objections aren't valid and don't meet the requirements of MCR 3.10K. The objections may only be based on the garnishment pleading itself and may not be used to challenge the validity of the judgment.
All right, ma'am, let me tell you what the record shows here.
Okay.
You were personally served with summons and complaint in this matter on January 29th, 2001. When you failed to respond, a default judgment was entered against you on May 7th, 2001. That judgment was renewed on May 10th of 2011, and then again on March the 11th of 2021. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. You, of course, ma'am, have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Court will send out to both of you an order denying the objection to garnishment. Thank you both for coming in. We are off the record.
Thank you very much, Your Honor.
Be on time, counsel.
I will.
All right.
I'm sorry, Judge, I'm back. I apologize.
What file are you here on now?
On 224, Your Honor.
Joseph present.
Yes.
And let's get, I see Mr. Presti here. Let's admit Mr. Presti. And I see Earlene Jones Brown. We'll admit her. And maybe we can get started a half an hour late.
I'm sorry, Judge.
Hello?
Yes, sir, Your Honor.
All right, ma'am, can you hear me too?
Yes, I can hear you, Judge.
All right, let's call our case then. This is file number 19162-224. Joseph Presti versus Earlene Brown Jones, Qualicare Health, Nursing Home. Could I have your appearances?
Good morning,
Hi.
Navjot Francis on behalf of plaintiff's attorney of record, P72322.
And your name is what, sir?
Joseph Presti, Your Honor.
And your name, ma'am?
Arlene Brown Jones.
All right. Oh, this is the wrong file, sorry. 224. All right, we are here today on objection to garnishment. That objection to garnishment was filed by Ms. Jones.
Yes, Your Honor.
You are the moving party. What is the basis of your objection to garnishment?
Because I feel that, Your Honor, that I'm being sued wrongfully, and when I left Mr. Presti property, which was on Agnes Street in East Point, I did pay him everything that was supposed to have been paid, and I paid it in full, and the property wasn't damaged. And when they gave me a letter, they sent me a letter saying that it was a property that was in Detroit on Warmer Street, a street that I never stayed on or know anything about. So that's where I was coming and asking for adjustment to a garnishment, because I feel that I don't owe Mr. Presti anything. We had this arrangement, and on the last day when I seen Mr. Presti, which was in 2019 in April, and I paid him the money. He came to the house, he got the money, and an agreement was for me to move out by the 29th, and I was out of his property, and wasn't any damage to his property.
All right, Mr. Presti, you have counsel here, so I will mute you. We'll hear from your counsel.
Yes, sir.
Thank you. Your Honor, MCR 3.101K1 states that defendant cannot use an objection to garnishment to attack the underlying judgment, which from her arguments, it sounds like she is doing. So we would ask for her objections to be denied at this time.
Yeah, ma'am, in this case, judgment was entered against you, and then you are now saying there's something wrong with the underlying judgment. Michigan Court Rule 3.101K specifically provides that you may not use the objection to garnishment as a method of attacking the underlying judgment. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. You, of course, have an absolute right to appeal my decision. That appeal must be perfected in 21 days today in the Wayne County Circuit Court. Now, Ms. Francis, are you appearing now on behalf of Mr. Presti in this matter? What's your?
Your Honor, it was just a limited appearance for today's hearing.
Okay. All right, then I'll send out an order. Thank you both for you all for coming in. We are all record.
Thank you, Your Honor.
Let's be safe. Do you have anything else, Ms. Francis?
I don't, Judge, and I apologize again. That was a 8:30 case that was still going on earlier.
Jesus.
You too. Thank you.
What is your name, ma'am?
My name is Shanika Clemens.
We are on the record calling file number 22-184620, Credit Acceptance Corporation versus Shanika Clements. This matter is scheduled for hearing at 10 o'clock on defendant's objection to garnishment. It's now 10:37. Plaintiff has failed to appear. We are going to proceed. Ma'am, what is the basis of your objection to garnishment?
Okay, well, in my divorce settlement, it stated that myself and my ex-husband are responsible for 50% of the repossession for credit acceptance. They were only able to serve me because I was in the home, so they're trying to put the whole amount on me. But I have in a settlement agreement that we both agreed to pay the 50% of the Explorer.
Well, ma'am, the problem that you have here is that a judgment was entered against you in this matter on September 16th, 2022. And under the court rule, Michigan Court Rule 3.101K, you may not use the objection to garnishment to contradict the validity of the underlying judgment. You have therefore failed to state a valid objection to garnishment. Now, you may have another motion, but in terms of objection to garnishment, ma'am, you failed to state a valid objection to garnishment. The court will therefore deny your objection. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days today in the Wayne County Circuit Court.
Could I say one thing, sir?
Yes, ma'am.
I did not receive my settlement for my divorce. It wasn't agreed to October 6th, and I didn't get the papers from the county up until January of this year. I didn't have anything to show you guys to even show that that was the agreement up until they gave me my papers from my settlement date.
Well, ma'am, you were personally served with summons and complaint in this matter on May 17th of 2022. The judgment was entered September 16th. Were you represented by counsel in your divorce?
Yes, I was.
Let me urge you as strongly as I can to have your counsel intervene in this, because you cannot use the objection to garnishment, ma'am, as a means of attacking the underlying judgment. And that's what you're attempting to do. The counsel can give you some guidance. You need to file another type of motion. Your objection to garnishment will be denied. I'll send out an order today. As I indicated to you, you have an absolute right to appeal my decision. That appeal must be perfected with 21 days today in the Wayne County Circuit Court. Thank you for coming in. We are on the record calling file number 21-173807, Galaxy International Purchase versus David Thornton. This matter is scheduled for hearing today at 10 o'clock on the defendant's objection to garnishment. It's now 10:41. Plaintiff counsel has failed to appear. We are going to proceed in his absence. Your appearance, please.
Yes, David Thornton.
I can't hear you, sir.
David Thornton.
All right, Mr. Thornton, what is the basis? Serve your objection to garnishment.
The charge or credit card was false. It was never mine.
Okay. Well, the problem we have here, Mr. Thornton, is that you were served with summons and complaint in this matter and filed an answer on March 15th of 2022. And then you were defaulted when you failed to appear for pretrial on April the 11th.
I know.
I set aside the default judgment was denied. And the judgment by default was ultimately entered on May 11th, 2022. You may not use the objection to garnishment under Michigan Court Rule 3.101K to challenge the validity of the underlying judgment. Having failed to state a valid objection to garnishment, that objection has to be denied. You have an absolute right, sir, to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Court will send out an order to you today. Thank you for coming in. You're off the record. We are on the record calling file number 211692227, HS Financial Group LLC versus Jimmy Hill. This is an adjourned date for a motion to show cause. The matter was scheduled today at 10 o'clock. It's now after 10:40. Could I have your appearance?
Good morning, I'm Daniel Waberman, P76609 on behalf of the plaintiff.
All right, we were last here together on this file on March the 1st, when the matter was scheduled for a debtor's examination. The defendant appeared, but this case had been transferred from another docket, and we heard it at 10 o'clock, and he apparently had a doctor's appointment. So the matter was adjourned to today's date and time, 10 o'clock. Agreement. Mr. Hill has failed to appear. Mr. Weber?
Your Honor, I would request a bench warrant. The current judgment amount is just 1,500 or just over that.
Look forward to your bench warrant, sir.
Thank you, Your Honor. Have a good day.
Be safe.
Thanks.
And we're off the record, and that's going to conclude the